Hello and welcome to this session of People's Law School, sponsored by the McCracken County Bar Association. My name is Alan Stout and I'm a lawyer with the firm of Stout, Farmer and King here in Paducah, Kentucky, and I'm here today with my partner Todd Farmer, and we're going to be talking about various aspects of bankruptcy. And bankruptcy is a process which has been established many years ago in our country. And in fact, the Constitution of the United States of America, Article 1, Section 8, specifically provides that Congress shall enact laws in regard to bankruptcy matters. The founders of the country felt that this was important, that we establish procedures and laws dealing with bankruptcy to deal with issues of people who had difficulty paying their debts because there was a period of time when people would be put in jail for failure to pay their debts, what we call debtors' prisons. And debtors' prisons were in England, and in fact we had debtors' prisons in this country in the early years of the colonies. Many people who were jailed were jailed for either crimes or for failure to pay debts. And it was felt that there was a need to distinguish between those two types of reasons to jail people, and there was developed in a process whereby people would be allowed to file bankruptcy, and that has developed through the years to the process we have today. Our law firm is heavily weighted in bankruptcy-related matters. We represent people who file bankruptcy. We also represent creditors who seek to recover money from people who have filed bankruptcy. I also serve as what's called a Chapter 7 bankruptcy trustee. And we are involved in all aspects of the bankruptcy process and have been for in excess of 25 years. One of the underlying fundamental concepts of bankruptcy is to provide a fresh start. That is, to provide a fresh start for people who have become overly encumbered in debt, and that is the basic premise of the bankruptcy laws in this country. To provide a fresh start not only to individuals but couples and businesses from time to time who find themselves in financial distress for any number of reasons. The process, and we're going to talk about the process some here today, and then we're going to talk about the various types of bankruptcy. And anytime you hear bankruptcy referred to, you'll hear about chapters. And the chapters are used to refer to the different types of bankruptcy, such as Chapter 7, which is what we commonly refer to as a straight bankruptcy, Chapter 13, which used to be called a wage earner plan, but it's an opportunity for an individual or a married couple to reorganize their debts under the protection of the bankruptcy courts. There's Chapter 11, which is a business reorganization, and Chapter 12, which is a farm reorganization. We're going to talk a little bit about all these bankruptcies, but before we do, I'm going to talk to you a little bit more just about some of the more recent changes in the law and how we've evolved to where we are today. The process of filing bankruptcy usually involves meeting with an attorney, whereby you discuss with the attorney your financial situation, your debts, your assets, what got you into the situation you're in, and from that the attorney then makes a decision as to the type of bankruptcy you file. After the initial meeting, there is a bankruptcy petition which is signed and filed with the federal court, and all the bankruptcy process is governed by the federal court system. And the actual location of the court where the clerk office sits, where the bankruptcies are filed in the Paducah area, is in Louisville, Kentucky. We are in the Western District of the United States Bankruptcy Court for the Western District of Kentucky, the Paducah Division. However, the cases are actually filed in Louisville. About 3 years ago, there was a significant change in the bankruptcy process in Kentucky, which allowed for electronic filing, what we call electronic case filing. And now all of the bankruptcies are actually filed electronically, although the main server to handle the files and the clerk's office is located in Louisville, Kentucky. We actually file the bankruptcy cases online, and the entire case is administered online. After the bankruptcy case is filed, in some types of bankruptcies, a trustee is appointed who will then oversee the administration of the case. For example, as I indicated earlier, I serve as a Chapter 7 bankruptcy trustee in the Paducah Division, and accordingly, I am randomly appointed to serve on bankruptcy cases that are Chapter 7 in nature, and there's another trustee who also serves in the Paducah Division. After the bankruptcy is filed, there is what's called a meeting of creditors, which is a meeting where the debtor appears. The debtor is what we call a person or an individual, a couple, or a business that has filed bankruptcy. We refer to them as a debtor. The debtor appears at this hearing and is examined under oath by the trustee. Also at this hearing, there's an opportunity for any creditors present to ask any questions they may have. These hearings are recorded. There is a record made of the proceedings, and the debtor is under oath, which means that the debtor is subject to penalties of perjury if they should lie under oath, and they can be prosecuted for other types of bankruptcy fraud or bankruptcy crimes. After the 341 meeting, or the first meeting of creditors as we refer to it, there's a period of time when creditors can object to the bankruptcy, and that requires filing of an adversary proceeding, or I describe it as a lawsuit within the bankruptcy, if any of the creditors are going to make an attempt to contest the bankruptcy or to perhaps throw the bankruptcy out. There's a period of time of 60 days when the creditor has an opportunity to do that, and if the creditor does not file an objection within that period of time, then the debtor will receive their discharge. And that is what the debtor's goal is whenever they file a Chapter 7 bankruptcy, is to receive a discharge. In a Chapter 13 setting, it's a little bit different because the debtor proposes a plan to repay a part of their debts over a 3 to 5 year period of time. We'll talk about the different types of bankruptcy now, and with me today is my law partner, Todd Farmer, and he's going to talk to you a little bit generally about Chapter 7 bankruptcy, which is what we often refer to as a straight bankruptcy.
Thanks, Alan. Really, as Alan mentioned, the two types of bankruptcy. The Chapter 7 is the type of bankruptcy that most people are most familiar with, and when people ask me what a Chapter 7 bankruptcy is, I tell them that a Chapter 7 bankruptcy is a big eraser. And what someone trying to file a Chapter 7 is trying to do, they are trying to erase or discharge all the debts that they have as of the day that they file bankruptcy. Well, the first question that I usually get about a Chapter 7 bankruptcy is what type of debts are dischargeable, and what debts can I get rid of, and what debts can I keep. And I tell people that the easiest way to answer that question is to tell you what debts you do have to pay after a bankruptcy, and those are what I refer to as non-dischargeable. For example, if you had a student loan you would be required to pay after a bankruptcy just like before. Certain types of back taxes, if you owed back payroll taxes or certain income taxes, those most likely are non-dischargeable, and you'd be required to those even after you file bankruptcy. And the third most common one that we see are obligations that you were ordered to pay as part of a divorce. If you were in a divorce setting and the divorce court ordered you to pay certain debts, it's likely in some instances that those debts can be non-dischargeable as well. Well, what that means is most types of debts that people have are dischargeable. And the most common debts that we see with people are really come into two categories. It's either credit cards, consumer type debts, or it's outstanding medical bills.
What are the most common causes you're seeing in the practice of people filing bankruptcy?
Well, you know, when I got into this area, I really had a misconception of the kind of people that file bankruptcy, and I tell everybody that I meet with, and in now 9 years, I've only had one person in 9 years that I felt like meant to be there. And people come to us really in just a couple of categories. One, they've lost a job unexpectedly, and they've had a hard time replacing their work. They've had a significant medical emergency, whether that be a stroke or some significant medical condition, or they've had a divorce and they've had to split up a number of debts, or they've had a business failure. And usually most people that file bankruptcy end up in really one of those four categories.
What about credit card debt? I know there's an awful lot of publicity regarding the credit card debt that people incur today, consumer debt. What role do you see credit card debt playing in the bankruptcies that you see?
Well, most of the bankruptcies that we see, I would say credit card debt is probably 70 to 80% of the debt that people are trying to discharge. And you know, I think the credit industry did a very good job of confusing people when the new bankruptcy law passed, because I have a number of people come in now and say, well, I thought you couldn't discharge credit cards anymore. But that's a little bit of misinformation, and those debts are still dischargeable under most circumstances.
Why don't I talk a little bit about the changes you've referred to, and then we'll continue on with Chapter 7, bankruptcy. 2005 was what I would characterize as a watershed year in the bankruptcy arena for two reasons. First of all, Congress in 2005 made a significant change in the bankruptcy laws when it passed what's called the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. It was signed into law by President Bush in April of 2005, and it actually went into effect in October of 2005. This was the most significant change in the bankruptcy laws in 25 years. The last significant change before this most recent change was in 1978. And since that time, there had only been relatively minor changes. And as a result of a strong lobby by the credit card industry and the consumer credit industry, there was a significant change in the law that passed by Congress. Another interesting occurrence that happened in 2005 was at the same time Congress was debating the Bankruptcy Abuse and Prevention Act, the state legislature of Kentucky passed a law to significantly increase exemptions. And the exemptions are what people get to keep when they file bankruptcy. So in a minute we'll talk to you a little bit more about exemptions and explain to you how those work. But the theory behind exemptions is whenever people file bankruptcy, as I indicated to you initially, the underlying theory is to give people a fresh start. And the law takes the position that in order for people to get a fresh start, there must be certain things for them to be able to keep to start over with. So there have been exemptions carved out. The significance of the 2005 changes of the law in Kentucky was that the legislature of Kentucky changed the law to allow debtors in bankruptcy to take the federal exemptions, which were significantly more liberal than the state exemptions. The bottom line is, if you file bankruptcy in Kentucky now, you can keep a lot more assets than you could prior to October of 2005. This all happened at a very unique time. The legislature of Kentucky was taking a position that was very much in favor of debtors, at the same time that the Congress of the United States was taking a position very much in favor of creditors, but yet they both passed in the same year. So we've had an interesting shift in bankruptcy law in the nation, and particularly in Kentucky, in the past 2 years with the implementation of these changes. And in fact, the changes did bring into effect a new concept in bankruptcy, which we call the means test, which provides that a criteria for certain people to file bankruptcy, and certain people are not eligible to file Chapter 7 bankruptcy. Todd, why don't you talk a little bit about that?
Well, really what the two questions that I get when people come to see me, first, before we've even really discussed their situation, they ask me, can I file Chapter 7 and can I keep my house? Those are really the first two questions, and I give all those people my favorite lawyer answer, and that answer is it depends. And what it depends on are really the facts of your case, but what the means test was designed to do, Congress felt like that everyone should attempt to repay their debts if they have the financial wherewithal to do that. And what it did, it put a national average income test in place depending on where you live, and how many people you have in your household to determine whether you should be eligible to file a Chapter 7 if you're below that amount, or if your income is significantly higher than that amount, that you should attempt to have to repay all or a percentage of your debts. And that's really a fairly complicated formula to determine how much an individual has to repay, because it's based on how many dependents they have, what county they live in, what assets they owned. But it comes up with what sort of an average of what Congress believes was a reasonable amount for someone to pay. The other question, the main question that I get from people is, I want to file bankruptcy, but I want to keep my stuff. That's generally what I hear. And
what can I keep? That's what people generally want to know. If I file bankruptcy, what can I keep?
Right. Well, and that's really, there's two issues. One, that many people don't realize, I had a situation the other day where a lady came in and said, well, I need to file bankruptcy, but I had to borrow a little bit of money from my mother, and if I file bankruptcy, I just won't be able to pay her back. And I said, no, you can do that. The bankruptcy laws allow you to what's called reaffirm or keep a debt. And I tell people the easiest way to understand what reaffirming a debt means is you're telling the bankruptcy court, I know I don't have to pay this debt, but I'm filing bankruptcy, but I'm willing to be liable for this debt after the bankruptcy, just like before. So an individual can voluntarily reaffirm a debt if they need to.
From an attorney standpoint, though, while we work with people in terms of reaffirming a debt on essential debts, such as reaffirming on a home so that the people still have a place to live, or reaffirming on a vehicle so the client still has a means to get to work, we still have to be careful in not allowing people to load up on too much debt, because if they come out of the bankruptcy with a lot of reaffirmed debt that they still cannot service, they can find themselves back in the same boat. And that, from that standpoint, the bankruptcy court from time to time will actually bring people into court, and the bankruptcy court will question them about their ability to meet their obligations with that reaffirmed debt.
And I think that's one of the key benefits of the bankruptcy code and relief is every person that files bankruptcy, no matter what chapter, is required to submit a monthly budget. And I think filling out that budget makes everyone take a long and hard look at what money they have coming in and what their expenses are, to make some good choices so that down the road they don't leave themselves in that cash-strapped position.
Though two components of the law, the new law that went into effect in 2005, was debtors, before they could file bankruptcy, were required to complete a credit counseling session before they actually file the bankruptcy, and then they're also required to complete a financial management course before they come out of the bankruptcy. So there's a ticket in and a ticket out, and those I've had numerous clients tell me have been beneficial to them. Why don't you focus a little bit on the exemptions?
Sure.
This is what, if you file bankruptcy in the state of Kentucky, essentially what a person can keep. And they may be surprised, the people may be surprised to realize what all they can keep.
Well, one of the biggest surprises that I think people have is that the exemptions are actually fairly generous. For an individual, if an individual files bankruptcy today, they're allowed to have up to $20,200 in equity in their residence. So for a married couple that were filing together, they could have up to $40,400 in equity. Well, that's not what you paid for it. And I tell everyone, equity is how much money would you have left if the property were sold and you paid off any secured debt that was associated with that. An individual is allowed to have up to $3,225 in equity in a vehicle, or $6,450 for a couple. They're allowed to have up to $10,775 each for household goods, which are furniture, clothing, televisions, household type items. And one key there, and that's at today's replacement value. That's not, if you bought a couch for $1,000 and you've had it for 5 years, its replacement value today, maybe $200. And for most people, I have found that when you add that together, that's over $21,000 for household goods. That takes care of just about every person that we meet with on personal items. If you were a a plumber or a carpenter, or you had some specialized tools, you can exempt up to $2,025 per person any kind of tools of the trade that a person needs to generate a living. And the last one, and the most significant, is what I'll refer to as a wild card exemption. You can apply that to money in the bank, or jewelry, or guns, or antiques, anything like that. It's $1,075 per person, but many of the people that we meet with do not own a home. They're renters. Well, if you're a renter, you get to use an additional $10,125 like a wild card. So a person's wild card exemption becomes a little over $11,000 per person if they did not own a home that they could use if they had some other asset or they had additional equity in a vehicle.
And those figures are then doubled for a married couple.
Yes, yes.
Well, that kind of covers Chapter 7 bankruptcy. Chapter 13 is the other type of bankruptcy that individuals and married couples look at. And this is where a situation where the debtors file a plan to reorganize or restructure their debts, usually over a 3 to 5 year period of time. Many times a Chapter 13 bankruptcy is used if the clients have been foreclosed on and their house is about to sell at the courthouse door or something like that. What we can do is file a Chapter 13 bankruptcy for the person. We can restructure their unsecured debt and in fact lump the arrearage that they're behind on their house payments over into the unsecured pool and pay off those debts over a period of time. Also, another significant thing that occurs when a Chapter 13 bankruptcy is filed, it stops all the interest on unsecured debt, which with credit card debts and a lot of other type of financial type obligations to consumer lenders can be very significant in and of itself. Chapter 13s are being used more and more since the changes in 2005 because of the means test that Todd referred to a while ago. Some people do not qualify for Chapter 7 bankruptcy because their income may be too high, and if they fall within certain limits, we still may be able to file a Chapter 13 bankruptcy for them also. Basically, Chapter 7 and Chapter 13 are the main types of consumer bankruptcy relief that's available to people. We want to talk just for a minute about a form of bankruptcy which is called Chapter 11. And Chapter 11 is a form of business reorganization. And it's an opportunity for a business to reorganize under the protection of the bankruptcy courts. And everything from large companies such as Texaco, DuPont, down to smaller businesses have sought relief under Chapter 11. Todd, why don't you talk a little bit about that?
Sure. One thing I forgot to mention on Chapter 7, which I think is a big benefit to people, I just wanted to bring up, is what does a Chapter 7 stop? And I have many people come in every day and they are getting inundated with phone calls from very just nasty collectors. And I tell everyone that files a Chapter 7 that it stops all collection activities. A Chapter 7 or a Chapter 13 can stop wage garnishments, it can stop collection activities, it can stop those phone calls from 8 a.m. to 8 p.m., and will even stop lawsuits. I just want to make sure people realize that just because a lawsuit's been filed doesn't mean that you can't get some relief under bankruptcy.
And you know, the power of the bankruptcy court you refer to there is what we call the automatic stay. And the automatic stay stops any creditor from taking any act. And in fact, the automatic stay is a very important tool in the Chapter 11 business bankruptcies as well. So
Sure.
Why don't you talk about
Sure.
those a little bit?
Even though Chapter 11 is available to some individuals, it's really designed for businesses. And what it is, it is a reorganization. It's really for companies that have got into a situation where their current debt load has become more than they can handle. And it's designed to, the day a bankruptcy is filed, the collection efforts will stop for a period which is called the period of exclusivity, or the period of time when it's kind of a cooling off period where the debtor's given an opportunity to say, okay, I know I've had some trouble in the past, give me a little bit of time to formulate a reorganization plan. And what will happen in the Chapter 11, a company will take anywhere from 90 days to a year sometimes to come up and formulate a reorganization plan that they will then take out to all of their creditors and say, okay, here's my economics today. These are what assets I own. these are what liabilities I have, and this is what kind of income I think that this company can generate on a going forward basis, and this is what I propose to repay you what I owe you.
The Chapter 11 bankruptcies from time to time can really help a business survive. I know we've seen situations even in this area where had it not been for the Chapter 11 bankruptcy, a business would have folded, gone under, and those jobs would have been lost. So from time to time, Chapter 11 can actually provide a means to help a business survive and restructure and keep those jobs in place in the economy. There is another type of bankruptcy which is less frequently noted, which is Chapter 12, which is a form of farm reorganization, and we won't spend a lot of time on that today, other than just to mention the fact that if any farmers are in financial distress, it is something that's available to them. All this being said, let me just wrap up with some final points. First of all, we view bankruptcy as a last resort. That being said, it still is a very powerful tool. Many times we will work with individuals or businesses in particular where we will try to restructure or reorganize a business without even having to file bankruptcy. That's what we call turnaround management and workout consulting. Many times we will try to work with a client to avoid filing bankruptcy and work with creditors in an attempt to avoid bankruptcy. However, sometimes still the bankruptcy is necessary. It's a very powerful tool. It's a very powerful business tool that can be used, and when it's used effectively, can help individuals and businesses alike. In 2005, over 2 million people and businesses in this country sought relief under the Bankruptcy Code. That sheer number of 2 million indicates how pervasive through society debt problems are for individuals and businesses alike. It also indicates how important it is to have laws in place for individuals and businesses to be able to handle these debts, either through seeking a discharge or seeking a reorganization and a restructure. So, in summary, we do view bankruptcy as a last resort. However, that being said, it's a very powerful tool which can help individuals and businesses alike to restructure and survive. Todd, do you have any final comments?
Just a couple of things. One thing, when we're talking about the period in a Chapter 7 or Chapter 13 bankruptcy that a case is pending, there are some type of debts that are non-dischargeable. And I tell everyone, if someone were to owe you money and you were a creditor and you think that you've been wronged in some way, you really ought to seek counsel. Just when in doubt, a phone call with an attorney that specializes in this area could really be beneficial to you.
All right. Well, thank you very much, and we appreciate the McCracken County Bar Association and the facilities here at the Community College for allowing us to make this presentation to you today. Once again, my name is Alan Stout. I've been here today with Todd Farmer. We are partners in the law firm of Stout, Farmer, and King here in Paducah, Kentucky. Thank you very much.